Ooh, this is a strange thought catalog. I'm very backed up on uploading recordings. I've made a lot of recordings that have already amended things and attenuated some things that of the latest recording that is at this point of making. At the time of making this recording, the last thing on my YouTube channel is a 3-hour upload on hate speech, which, the first hour and a half of which is basically very rambly and embarrassing and loose thinking and okay, anyway, I have been very, very focused on making a public submission on the hate speech legislation, and in the process of which I completely wrote a new hate speech bill, essentially. The only thing that it doesn't have, which I certainly won't have time to do because the deadline is tomorrow. How do I exit this? What's the point? Oh yeah, so the only thing that I don't have. How do I exit this full screen thing? Yeah, the only heading that I didn't, penalties and considerations in sentencing. I'm just going to admit that section of the bill because I don't have the time, and also obviously the bill would require editing and revision, but it is, I have actually constructed a completely workable structure for hate speech, which has a lot of innovations built within it that actually are really great at. There's a provision here. Provision for the coherence and self-consistency of the Supreme Constitutional Order. Because in the what I call it is the definitional elements of hate speech, or so the crime of hate speech or constitutional damages, either one is the same crime, and in that construction, there are two general exemptions essentially, or two grounds for general exemptions. And those two grounds are essentially, I'm not going to be able to, because this is a lot of writing, so this is just a bit of an overview, but essentially there are two separate assessments, fairness and validity. And if you can prove that your comments are fair, then that gives you an exoneration, essentially. But if the comments are assessed to be invalid, then they are then that is an independent indicator of guilt. And because these are two separate tests or separate assessments, they could both be performed, and obviously they should agree, that the conclusion of each assessment should agree. But if they are inconsistent, that means that there is an error in law. And I'll just read this because I think that this is quite an ingenious innovation. It says, provision for the coherence and self-consistency of the Supreme Constitutional Order. The two grounds of validity and fairness act as independent indicators of guilt by their separate assessment. However, because, by the way, also an independent finding of unfairness with the element of constitutional damages, which has a separate definition as well. So if there if incitement of constitutional damages is present, a finding of unfairness is an independent indicator of guilt. But specifically, the finding of fairness, which is an exoneration, and the finding of invalidity, which is itself all you need is if your comments were invalid, because invalidity also includes essentially the threshold. Like a Venn diagram, invalidity also covers the same ground as constitutional incitement, inciting constitutional damages. So invalidity subsumes the element of constitutional damages. So anyway, as I was saying, so basically these are independent assessments, and they should correspond and agree with one another. But if you do both assessments and it turns out that the person should be exonerated, but also that the person should be guilty, then the presiding officer has made an error in law. Sorry, let me read the provision here. Excuse me. The two grounds of validity and fairness act as independent indicators of guilt by their separate assessment. However, a finding of fairness confers exoneration, and a finding of invalidity confers guilt, with no further assessments needed to secure such an exoneration or indication of guilt. If, however, both assessments are performed and both findings have been arrived at and fail to both agree and correspond to one another, as in both guilt via invalidity and exoneration via fairness are both ascertained by the separate assessments, then some provision of the Constitution, and perhaps especially the provisions of the limitations clause or equality clauses, have been incorrectly applied or interpreted, and an egregious error in constitutional law has been propounded by a presiding officer in need of immediate rectification or constitutional law review and reconvention as required to recover the constitutional order from the apparent disjuncture in jurisprudence which infringes the Constitution, that needs some grammatical cleanup, by seemingly imposing an untenable paradox of self-inconsistency upon the Constitution, proximately caused by either incoherent or badly developed ratio decidendi, that must be immediately reconciled and cured for the proper administration of justice and to preserve the standing and moral coherence of the supreme constitutional legal order, as is the appropriate corresponding duty fit to match those powers wielded by presiding officers who functionally dispense justice in the name of such in the name of the supreme in the name of the constitutional order. And thereby wielding its supremacy in the function functional role. Yeah. Well, it doesn't have to be perfect. It's just. This is just the substance, really. This needs to sort of be more concise. And so, essentially, these two separate tests have the ingenious byproduct of essentially creating a you see, there used to be conventions of law review in the appellate division. It's kind of fallen out of favor because since the constitutional order came into force, the Constitution kind of held that role. The problem is that when constitutional jurisprudence is incoherent or is disparate or has disjunctions within it, then you've got an unbalanced or you've got a self-inconsistent jurisprudence, which is, I would argue, itself a threat to the standing of the Constitution. And there, I've got other really good paragraphs in this, like under. Look, I still need to edit this as well, but here we go. Validity. What was that aspect that I wanted to? The wrong font. Yeah, it is the wrong font. Definition of inciting constitutional damages. So the inciting constitutional damage essentially is either inciting unlawful commissions or omissions. I'm just trying to talk about this off the top of my head. I actually didn't want to talk about this bill, but I wanted to make other comments. So I'll make a recording specifically about this, because I do think that I have made very good progress. And I do think that this would essentially fix almost everything that's wrong with the country in terms of the slide towards authoritarianism, and essentially that the values, the fundamental constitutional values have essentially been, that was the thing that I wanted to talk about. So I get into some discussion where I say, because I mean, throughout this bill, I talk about how these provisions would essentially hang together, and how it would function as a coherent, let's say, morally and reasonable structure that facilitates the Constitution. Tolerance is the cornerstone of any liberal democracy. The necessary line for distinguishing when to stop tolerating intolerance must be clearly and plainly drawn, and the tolerance of those who utilize their freedom of speech, even when the form that speech may take is that of open chauvinism or bigotry on the basis of mutable characteristics, should perhaps best be regarded as being naturally relegated to the informal regulation offered by society and culture itself as a whole, through social norms of impoliteness, so as to attract societal, cultural scorn or other forms of taboo, shaming, or censure, without the heavy hand, in brackets, without the heavy hand of the state to impose moral concordance, and thus without state interference to deflate the sails of moral argumentation and confrontation. Otherwise caused by chilling robust debate, as would be affected by coercive sanctions, as would be the effects of coercive sanctions, which would label, which may blanketly label such expressions as unfair discrimination, and thereby making them difficult to morally investigate, engage, or confront within a vibrant public square. And such debates would not merely be left to those privileged beneficiaries of academic or religious credentials to hide behind their dogma or their academic standing as an excuse to enjoy more freedom of speech than others. Thereby each individual, according to their own individual assessment, beliefs, and discretion, as moral and moral judgment, can explore ethical sentiments and ethics as an organic part of personal exploration and moral investigation, and such exchanges as the backdrop of an individual's freedom of association and conscience, therefore, are necessary to be openly negotiated by free exchanges. Exchangers of such views, which should not attract criminal sanction until it rises to the level of threatening to incite unlawful forms of harm or other kinds of unfair discrimination, or other kinds of already established forms of unfair discrimination, i.e. the institutionalization of unjust administrative action, or repeal of any constitutional protections that are already in place, or threatening to indirectly impact on the rights of others by way of removing people's political freedoms or other constitutional rights which allow such people to enjoy their full measure of owed tolerance and liberty within our shared and open society, within the magnificence of our open liberal democracy that does not impose strict openness, but tolerates some forms of intolerance where that intolerance does not exceed the bounds of the intolerance paradox, or said differently, does not threaten the preservation or supremacy of the South African constitutional order. And there is another note that I have to add on to that, but it's not relevant for me to read, and it just makes all the conceptual work in all of the different things, like as there's one permutation of kind of interrelated issues, which someone reading the bill might, when thinking about it very carefully, think that there's an apparent contradiction, but there actually isn't. It just just needs some clarification to show that the whole thing is completely self-consistent and coherent, and also sings well with the Constitution. Okay, so definition of hate speech or constitutional damages. I didn't read that out. Maybe I just want to make this recording all about this. Expressions in the form of right, definition of materials, definition of made unfairly, definition of inciting constitutional damages. Did I read the note here? Okay, let me just read the note on as even acts of parliament. Oh yeah, this is an interesting sort of thing. Maybe I should read this. Anti-constitutional propaganda is synonymous with constitutional damages in respect of any materials that amount to claims targeting any characteristic which further includes either, one, the encouragement of permissibility that amounts to indirect as well as direct incitement or threatening of an unlawful source of harm to be committed against someone or group being targeted on the basis of the characteristic, or threatening or campaigning for the removal of constitutional rights, or overtly making encouragement or inciting solicitation towards some imposition of special treatments in law on the basis of targeting that characteristic, which would lead to either infringing upon constitutional rights or fundamental constitutional values, while circumventing or foregoing the limitations clause in the Bill of Rights of the Constitution and or any relevant equality clauses and provisions. Note, as even acts of Parliament wishing to amend the Constitution with the requisite majorities in place must first have their constitutional amendments tested and passed against the limitations clause in the Constitution before becoming settled law, so as not to create a paradox of de facto legal positivism and parliamentary supremacy, when a South African Parliament should always itself already be foremost bound by the Supreme Constitution and only capable of seeking a legitimate mandate from the people through campaigning by political manifesto, and such a campaigning and manifesto should obviously not itself incite constitutional damages or include unprotected speech, at which point it would have already been unlawful and invalid as incompatible with the supreme law. In this way, the Constitution may only be amended to increase or expand on the protections it provides for, and not to reduce or negatively subtract from any of its already existing provisions, which relates to any existing protections, freedoms, or rights in the Bill of Rights and Section 1 of the Constitution. In brackets, the Bill of Rights may not be reduced. It is even unlawful for anyone to seriously contemplate this, as it would amount to the criminal conspiracy to commit constitutional damages in the forms of perpetrating actions inconsistent and invalid with the Constitution. Parliamentarians are not above the supreme law, and those enthroned with institutional power should especially have their power checked by a law that confirms compliance with constitutional values and the duties imposed by the rights in the Bill of Rights. So this is, I think, a very good formulation for hate speech that centers around inciting constitutional damages. I didn't actually read the definition of hate speech or constitutional. So the actual definition of hate speech and constitutional damages is I actually should put the definition of hate speech or inciting constitutional damages. Should be that's maybe another point that I should just be hate constitutional damage. Okay, anyway, I guess I have to work out the tense. I only recently worked out that it could be called hate speech or constitutional damages, but maybe just calling it hate speech would be easier. But it does also, what's just occurred to me now is that if you can prove constitutional damages, then essentially that would be that would also sort of simultaneously always correspond or correlate that the materials were unfairly made. So I'll have to think. It just means, I mean, this only, yeah, this just means that so I'll have to think about how to classify this, because I think basically then the construct of inciting constitutional damage is probably a sufficient condition, but you have to go through the other assessments um, to properly ascertain that sufficient condition um, has been met. So it's as if sort of invalidity and fairness are, or probably invalidity more so than fairness, because if so, I mean, if constitutional damages have been incited, then I don't think it's possible that it could be fair. Yeah, so it's sort of, there's actually sort of but if you're dealing with certain characteristics that are explicitly so all the characteristics that are specifically protected in the freedom of expression provisions, or that are caveated in the freedom of expression provisions in subsection 3 of section 16 of the Bill of Rights that correspond to I think it's race, gender, religion. So there are 4, I believe. It's race, gender, religion, ethnicity. I think it's those 4. So if constitutional damages are found in relation, so I just need to add that here, that then you probably wouldn't have to do the other assessments. Anyway, these are kind of technical points. It's so here's did I read out? Here's my definition of hate speech or inciting constitutional damage. So you see, I guess I can't just call it inciting constitutional damage, because then if you were inciting constitutional damages towards some mutable characteristics that don't have any special protection, it might actually be okay. I mean, here's just an example. Imagine if you, because you see, like I don't have a distinction. The bill actually does, my version of the bill does not require me to make a distinction between morally relevant mutable characteristics and morally targetable, or let's say valid targets of, imagine you want to say pedophiles should be hung by the neck until dead. Imagine you wanted to say, I want the law to change so that we can have the death penalty for pedophiles. Imagine that was what you wanted to campaign. Now, technically, that could be construed as hate speech, except that pedophilia, which can be characterized as a mutable characteristic, or it could at least. I do sometimes talk about characteristics that are quasi-mutable or immutable. That's basically, but essentially, I have two. The only relevant distinction in terms of my version of the bill is mutable characteristics and immutable characteristics. But there are some mutable characteristics which do have extra protections from the Constitution, and those would basically fall under, well, if you can have a finding of inciting constitutional damage, and they are protected grounds in section 16 subsection 3 of the freedom of expression caveated exemptions, then in those cases, merely finding incitement of constitutional damage would then be an independent indicator of guilt, and you wouldn't have to go further. You wouldn't have to look at validity or invalidity. It would already be established. But essentially, oh man, I'm talking about this and I haven't even said what the definitions are. Okay, so I mean, the reason why I make the distinction between mutable and immutable, um, I'll talk about that later, but that's because it's at least if you can classify some characteristics as immutable, that can be a factual ascertainment that can be made, even though that there is still some confusion in that distinction, because there are some, like pregnancy, I regard pregnancy as a quasi-immutable characteristic that could be regarded as both mutable or immutable. And in some sense, that only matters with regard to the assessment under the ground of validity, or at least the ascertainment of invalidity. Okay, so let me read the definition of hate speech. Okay, so the propagation, you see, this is the second, I'm trying to make a whole thing in 2 days. I really left this too late, but I was very sick with flu, or with a cold or something. Okay, the definition of hate speech or inciting constitutional damage. I need to work on that name still. The propagation of views, beliefs, sentiments, and opinions through materials inciting constitutional damages. Okay, that's the first element. The second element is which are made unfairly, without at the very least, and then these are, and then this is the paragraph of exemptions, of general exemptions. Without at the very least an attempted substantiation alluding to some ground that eliminates invalidity or providing for the fairness of such materials. So you either have to prove that it isn't invalid, that its invalidity is eliminated, or providing for the fairness of. So if you prove that you have eliminated invalidity, or you prove that your materials, or you provide grounds for that evidence the fairness of of the materials under question, then fairness fairness can exonerate you, and fairness will exonerate you, and although if you cannot show that your materials are fair, you at least have to show that they're not unfair. And you have to somewhat defeat reasonable doubt that the materials are invalid. Sorry, I'm just talking about this. And then the second paragraph, or the second part of the general exemption is, or providing an atmosphere for an implicit or broader context being relied on to indirectly or virtually invoke a set of grounds that speak of the elimination of invalidity or provision of fairness to such materials. And so this basically means that it doesn't really matter if the communication, or the definition of materials is expressions in the form of writing, speech, or other mediums with contents intended to transmit or produce communication. So basically any communication, which essentially later goes on to explain that essentially your communication doesn't have to be perfect. It just has to kind of maybe suggest or allude or be in a context that implies essentially that there is missing context, and if that missing context can be supplied, then essentially the materials under review can be properly assessed by the courts or investigated. So essentially you can adduce context, essentially, and this is opening that door to adducing context and evidence of further context. Okay, and then I have a more specific definition of inciting constitutional damages, which I think I read out. Let me just read it again. Anti-constitutional propaganda is synonymous with constitutional damages in respect of any materials that amounts to claims targeted against any characteristic which further includes either the encouragement or permissibility that amounts to indirect as well as direct incitement or threatening threat of any unlawful harm or source of unlawful harm. That's a bit... Anyway, to be committed against someone or group being targeted on the basis of the characteristic, or threatening or campaigning for the removal of constitutional rights, or overtly making encouragement or inciting solicitation towards some imposition of special treatments in law on the basis of targeting that that characteristic, which would lead to either infringing upon constitutional rights or fundamental constitutional values, while circumventing or foregoing the limitations clause in the Bill of Rights of the Constitution and or any relevant equality clauses and provisions. So that's quite a mouthful, but basically you have, so which is another way of saying that essentially, if you are campaigning to have the law changed, your views must be balanced, and they must be balanced by the relevant constitutional provisions. That's just another way of saying that. And then I had that note about everything must go by way of the limitations clause. And then I've got my provision for the coherence and self-consistency of the Supreme Constitutional Order, which I think is actually, because it actually forces that there are moral standards that, in some sense, within the democracy. Okay, so let me talk about validity for a second. So invalidity is an independent indicator of guilt and also provides the full test for when hatred reaches a threshold fit to attract a criminal sanction for hate speech. Or inciting constitutional damage. Or incitement constitutional damage. Claims carrying an irrefutable presumption of... so in the first thing in validity is I've got like a subheading. Actually, I should make this a little... Claims carrying an irrebuttable presumption of invalidity. Let me make this bold. Okay, and then I've got a list of 5 things here. And and then I put a note before this. Let me read out this whole thing. Okay. Claims carrying an irrebuttable presumption of invalidity. In brackets, because such claims propagate hatred while simultaneously inciting constitutional damages when involving the immutable characteristics mentioned in the equality clauses 9.3 of the Constitution: race, sex, pregnancy, ethnic or social origin, color, age, disability, and birth. To service some very fringe cases involving this list of irrebuttable presumptions of invalidity, pregnancy should be considered a characteristic that can be considered both as a mutable and an immutable. Pregnancy should be considered a characteristic that can be considered I would, if I add the word quasi there, I might be able to shorten that. It's a bit verbose, but anyway. Okay, so as a note, we may have problems within our democracy, but no fundamental and serious defects with our owning of an open liberal democracy and society. So the first irrebuttable presumption of invalidity is: an open liberal democracy is fundamentally unjust or oppressive is a fundamentally unjust or oppressive model for structuring cultural, social, or political systems. Second claim is that the South African Constitution is a fundamentally unjust or oppressive document. The third claim is an individual's moral character or worth is determined by that individual's immutable characteristics. The fourth, irrefutably, the fourth irrebuttable presumption of invalidity is an individual, because of their immutable characteristics, bears responsibility for the actions committed by other individuals possessing the same immutable characteristics. And fifth, an individual, by virtue of an immutable characteristic, is inherently unjust, bigoted, or oppressive, whether consciously or unconsciously. So these are irrebuttably presumed invalid. And if there is a finding or an assessment of invalidity, then that is an independent indicator of guilt without having to make any other assessment. So if you do any of these five things, if you claim any of these five things, it is hate speech, according to this formulation of hate speech in my version of this bill. And the reason why this should be criminalized is because, well, first of all, I mean, it's basically to respect the intolerance paradox. But so if you campaign that an open liberal democratic democracy is a fundamentally unjust or oppressive model, then you're going to impose authoritarianism or theocracy or fascism or something else. So it's just. So you can say that we have problems within our democracy, but no fundamental and serious defects with our owning of an open liberal democracy and democracy or society. Invalidity is linked to, and this is interesting because when I was writing all of this, I had an interesting dream before I even started making this alternative bill. It was an interesting dream. I probably can't remember the whole dream, but in the dream, I remember the gist of it. I was sort of being questioned whether I wasn't in fact just a kind of social justice warrior underneath it all myself. And it's interesting because I do think that, I mean, look, what I'm about to say is not going to be that original or insightful, but I would say that, the general problem with our society or with culture itself is that we have these structures, we have this doctrine, but people don't understand it, they're not educated about it, it's not being promoted, it's being undermined, it's being, in some sense, it's the standing of the Constitution has been diminished because it's been misused and abused and scapegoated, and it's been culturally disintegrated and damaged because it hasn't been protected. It hasn't been considered sacred or sanctified. It has no means of protecting itself or something like that. But I would say that perhaps it has, though, created an appetite. I think that the 90s and the South African Constitution, the non-racialist moral, the moral golden age that we had in culture that has kind of dawned and that has been, which has now of late been subsiding and giving way and been diminished. That has been setting, the sun has been setting of our golden age, it's and it's getting very depressing, it's getting very dark, it's getting, that I think that in some sense it's because people, they are looking for sound doctrine, they are looking for moral clarity and coherence. And so but they don't have the temerity, they don't have the patience, they are instead trying to find counterfeits, but also they've also been misled by the politicians and by the political arena and by toxic rhetoric and toxic politics that has essentially diminished the standing of the Constitution and scapegoated the values in the Constitution and essentially eroded them and replaced them with nebulous, unprincipled legal tests that are fundamentally incoherent. So people are looking for a new dogma, or they're looking for a new structure, because they want something to stand on. They want a doctrine. They want some kind of moral thinking in their mind, and they are so thirsty for it, but they have attached themselves to a counterfeit, and a counterfeit that's not capable of producing a coherent set of criteria that actually is commensurate with the rule of law. You know, the actual hate speech bill as it currently stands in Parliament is a hideous monstrosity. You know, it is there to facilitate identity politics of the worst kind. It is there to facilitate the further erosion of constitutional values, and even to be used and leveraged by toxic politics that will continue to diminish and erode constitutional protections. You know, the reliance on democracy to boil out, you know, because people, man, I have this whole argument about, you know, this is where America is structured in a way that is fundamentally corrupt and wrong. For instance, because America is a republican democracy, which means that their republic is co-owned by their democracy, and the democracy is the dominant constituent of that arrangement. And democracy, therefore the republic, the American republic, is crushed down to the level of the democracy. And so they don't have a proper functioning republic. You know, a republic literally means the public thing. It belongs to everyone. It belongs to every citizen, whereas the democracy only belongs to the majority. So you don't want to live in a democracy. You want to live in a republic. You want to perhaps live in a republic that has an open liberal democracy. You want to have an open liberal democracy, but the country of South Africa is not a democracy. It's a republic. It's a republic that has an open liberal democracy. It is not a democracy. Okay, so these are just important distinctions to understand. And our republic also is governed by a supreme constitution, the values of which have been eroded and substituted for majoritarian groupthink and groupthink morality and a loose kind of nebulous consensus, which is very prominently utilized in the current formulation of hate speech before Parliament. In the current bill, it defines harm as including psychological and emotional harm, and it just gives a list of protected grounds. And so inciting harm could merely be the emotional damage that someone, or the emotional harm that someone feels when their views are contradicted, when their understanding of objective morality is disagreed with or refuted, or actually, or perhaps even ridiculed. So you can't really have a concept of inherent dignity if people are given the license and the liberty to associate that inherent dignity with their own political ideology or worldview. Because if you have that, then you're going to have a zero-sum game of dignity wars. Now, this is a kind of thing that politics and this is a kind of thing, I mean, this is what makes republics better than democracies, is that at least if you live in a republic, you can have some kind of rule of law that can supersede having a majority make these distinctions that define what is sanctified. So you can have a stable and complete system of values that's capable of conserving itself, that is capable of having stable values. Because if you don't have stable values, then essentially you have a kind of temperamental and impermanent structure, which no one, you have to build your house on a foundation. You can't build it on sand, on something temperamental that can change and go all over the place. So justice as well also requires this. Otherwise you can't have a justice system. You just have a system of government or a system of rules that are imposed or enforced. And the procedure that leads to what is legally enforceable and not legally enforceable is just merely promulgated by majoritarian edict. Now, the American legal structure, I believe, is essentially fundamentally corrupt, because the amendment section of the American Constitution is free game. It can be democratically dictated, essentially. It can completely be repromulgated. In fact, all the law in America is liable to being radically repromulgated or radically revised. And what is worse as well is that because they don't have the medium of a general common law and a supreme constitution that actually has values and not just procedural ideals. America has procedural fairness, but it does not have substantive fairness. It does not have substantive values. It has procedural values in some way. So it kind of tries to make this it has a kind of technical filter which it substitutes for the rule of law. So America has created a technical structure that it calls the rule of law, but in my argument and to my mind, America cannot substantively have the rule of law, because when you go to court and are doing something using the law, that law is liable to radical repromulgation. So whenever you go to court, you have to snapshot the state of the law, and then you have to use that state of the law and hope that the law stays that way while you're doing your litigation. And the law itself is often incomplete. It's not in principle, it's not fully fleshed out. It doesn't have a philosophical structure for everything. It only has provisions that have already been constructed by the legislature. The legislature has to make torts, or it has to make particular definitions of crimes or instruments of, it's all invented. It's all an experimental conjecture by the majority, by the democracy. The democracy is inventing the substantive law. It's not philosophically complete, or it's not in principle complete. It doesn't have a substantive, values-based bedrock. It has, maybe someone in the legislature wrote a list of nice things that maybe some states do have commitment to certain values, but do they have ways in which that those values reach legal remedies or translate into legal instruments that allow the individual to sue for reconciliation and self-consistency of the law as a whole, or to sue for a declarative decision about the incoherence of a particular part of the substantive law. You see, you can't even try to get a declarative judgment from a high court in America, because the court does not have the power to make pronouncements about the state of the law. It is the legislature's job to make the content of the law, and the judges may interpret it. Maybe they can make some kind of declarator, but it doesn't really, in some sense, so the general moral point that I'm making, it's somewhat moot. And justice, so justice in America is the rule of man. It's the rule of the majority. It's not the rule of values and objective criteria that must eventually sort of be coherent and work together. So they have a kind of, look, they tried to have the best of both worlds, and in some sense they've got elements of both. It's a weird mixed system, but I would say that they don't have a proper republic. They have a shell of a republic which is rented from the democracy. The republic in America is rented from the democracy, and it is owned predominantly by the democracy. And some possession of the democracy is claimed by the republic, but it's rented from the democracy until the democracy has the ultimate say to eventually do what it likes. Now, the South African system is completely unlike the American system. The South African system is a proper republic, and the republic, in its constitutional framework, is supreme. And the majority can't, by hook or by crook, subvert the constitutional order. Just trying to think, if my bill could actually be instituted through the Constitutional Court, I think it could. Because the whole thing is just an extension of the Constitution itself. It doesn't actually add any element that isn't already reinforced by the wording of the Constitution. It's, in some sense, the natural combination of such. Oh, that's good. I can add that to my submission then, because I can just say that if my submission fails, then I plan to take the constitutional, or take the parliament to court to compel them to institute this bill as the hate speech legislation. I mean, that's, that sounds very hubristic, and but I think that it is a coherent argument. That's actually pretty good. I just need to work on this some more. also going to make a recording about something else. Anyway, let me make that second recording now.